Well, who are these strange data protection guys? As a matter of fact, we've got our roots, well, one could say, in an opposite area. We come from marketing, and we are also still active in marketing. For the time being, we've got a 50-50% share. So we work as marketing heroes, and we work in the field of online marketing, corporate design, identity, podcast production, conference documentation, everything that you need. And then 3 years ago, we decided that this topic of data protection is becoming increasingly important. It's also becoming increasingly important for sustainable marketing activities. And there's a gap, a consulting gap in this field. There seem to be much less data privacy officers than are needed by companies. We need that additional qualification, and we therefore then obtained this qualification as a data protection officer and auditor by way of receiving a TÜV certification. We do marketing for ourselves, of course, in this sense, and we have our own podcast. And for the time being, we have one set of customers who we provide with marketing services, and another set of customers for whom we provide data protection services, because we cannot and do not want to offer both services to one customers, because there would very quickly be an interest of conflict. The data protection officer would say, no, all the things that a marketing officer and specialists need, all that data, we can't allow that to happen. Now, what's coming up on today's agenda? There are quite some things in this agenda. We are going to take a look at the most important data protection ordinance related topic. What is personal data? What are the obligations of those responsible for data protection? We see a lot of misunderstandings and lack of know-how. What are the rights of those who are affected by data privacy regulations? And what does that mean then for those who process data? We're going to take a look at the topic of consent and declarations of consent. A consent for marketing is a very important topic. And we're also going to take a look at what needs to be done and needed to be done if a so-called incident happens, if something comes up and a data gap arises. Now, we're going to then move from this dry matter to a not much more exciting topic of cyber security and security in general. We're going to take a look at many of those topics that you are already using: firewall, antivirus software, email, encryption, VPN, hard disk encryption. So we're going to take a look why all that makes sense, why you should have it, and what the background of all that is. And then we're going to move on to the most exciting part, most close to practical needs. We're going to take a look at software, apps, and tools. If you already use apps and software, and particularly in those situations where you work as an entrepreneur, it's very important in these instances to consider the criteria by means of which to select software and tools. We're going to take a look at websites and the associated topic of cookies. And then I brought along a set of tools and apps that almost everybody uses in their daily activities. And I'm going to also shed light on why this is not a good idea to use these apps and what alternative apps could be used. Fabian Scherer is going to take a look at the General Data Protection Regulation. The General Data Protection Regulation is something that everybody has heard about, and it has been around for a long period of time, since 2018. All the more surprising for a person like myself that so many of those points that we're going to take a look at haven't trickled down to each company, to each employee working in a company and each entrepreneur owning a company. And when it comes to the GDPR, people tend to love to engage in a fundamental discussion, which is what I would like to stay away from up front. Yes, general data protection has a lot to do with paperwork and paper trails. We experience a wide range of bureaucracy in Germany, and data protection can be annoying. Of course it can. Consent manager, cookie banner on websites and things alike are just some keywords to be mentioned in this context. And sometimes data protection doesn't make much sense. That's just a fact of life. That's just the way it is. But data protection not only protects data, but ultimately data protection protects the personal rights of those people who own this data. That is, your data, my data. And this is something that we need to keep in the back of our minds when we think about the various folders that you sit in front of. So if you take a look at what happens currently, if you see the fines being imposed on Google, Facebook, Instagram, and other data capture companies, you also, as a normal person, see that general data protection is something that has a clout, that makes a difference. And data protection, as a matter of fact, is something that has transpired to be and offer a real benefit to companies. This is what we have experienced in our own activities on various occasions. If you can design processes in a more relaxed manner, if you can see that you can make use of alternatives that can do a lot of work for you and keep a lot of work off your own desk, and data protection, and I hope this is something that will be your own conclusion after this workshop, data protection is something that one can wrap one's head around. But what is personal data? That is something that we have to look at the very beginning. Some of you may already have dealt with this topic, but I believe there is a lot of lack of know-how that we see when we look into the field. So let's take a look at Article 4, Passage 1 of the GDPR. And I'm going to quote, "Personal data means any information relating to an identified or identifiable natural person, data subject. An identifiable person is one who can be identified directly or indirectly, particularly by reference to an identifier such as a name, an identification number, location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person." Well, I assume that this is as hard a nut to crack for yourself like it was for me when I read it the first time. But when you look at it in your own time, it becomes more straightforward and understandable. If you refer to the GDPR, personal data is data that refers to a person that can be identified. That means you've got data on a person who you already know. This might be a telephone number of that person, an email address, a home address. It might be a customer, a staff member, whoever establishes a business relation with you might be such a person. It could also be data that refers to an identifiable person. And here there is a first question arising. Identifiable means that there is a key which makes it possible for you to conclude who's behind this key. The personal number would be a typical example, or a car registration number would be another example. And even if at first glance you do not believe that you're dealing with a date or a set of date that allows you to identify a person because you need that key, the General Data Protection Regulation includes these keys as personal data. So, should there be any misunderstanding, should we have to discuss whether the personal employee number is subject to GDPR? The answer is yes. There is some key that allows me to identify the person behind the PD, the personal ID. It's very important to keep the following in mind. Data that we're talking about in the context of the GDPR relates to personal data. That is to a person who's at the end of this set and chain of data, an individual person. That means, on the other hand, that data from companies, a general email address, info at, for instance, that would be data that does not fall under the GDPR. So, particularly in those cases, if you want to process the data that you have collected, you need to keep that in mind. And when you deal with individual companies, with sole traders, it's difficult to distinguish between the data of individuals and the owner of the sole trader. Very often, the data of the natural person are also at the same time the data pertaining to the business. And very often you've got a mobile phone number, and this mobile phone will be used for both personal affairs and business affairs. And this type of data very clearly is subject to data privacy regulation. May I ask a question? Of course you may. As soon as this person, I as an individual entrepreneur, decides to give my mobile phone number, I would basically get out of the business environment. Right. You're allowed to do with company data that you're not allowed to do with individual persons. You can send marketing material to companies while you are not allowed to do so to individuals. So you can send an advertising mail to 50 potential cooperation partners, but it may be difficult if such a person is only a sole trader, a natural person, as it were. So you need to be aware of this trap. It doesn't happen very often because the person who is a sole trader, who is a sole entrepreneur, provides their data deliberately so. But if something goes south, or if you meet in front of court, it becomes very exciting. So you need to be alert and aware of this fact, particularly in those cases where you have to deal with a lot of individual entrepreneurs. I've also got a question. Does that mean if you carry out a mapping from a website, say that you can list theaters because there are companies? Well, company data that would be provided by companies that you find in Google, that you find in industry directories. You can do a lot of things with that data. And that is exactly what the normal platforms are doing. The yellow pages and other data aggregators, they look for company data from websites. They publish them in the form of a directory. And that is where things become exciting. If this data is at the same time my own and private data as a private person, this is just one example. So yellow pages say, well, I found it on the web. You presented it. Yes, I can respond, but it's still my private address. I've got my office at home. So then you can start arguing who's right and who's wrong. But which kind of personal data do you know? You just give me some data. If you look at the definition, there should be a lot of things that come to your mind spontaneously. Interaction, it's up to you to engage. And nobody finds the unmute button. Well, name, address, telephone number, the imprint, date of birth, size, weight, telephone, diseases, gender. Excellent, right. Bank account, right. That's also interesting. There's something that you can dispute about, whether this is an identifiable data or not. Social contacts, that's an interesting point indeed, and it's something that you could also start to debate about. Text number, text identifier. So you're following the right track. And now I found my chat window. Hobbies is something that I haven't heard in the context of personal data, but yes, of course, if it's connected and related to this data, purchasing behavior, very interesting, payback cards, for instance, participation in events, well, that very much depends whether this is personal data. It's the name, the contact, the participation in an event is not really relevant as personal data. In this context, it very much depends on how data are connected and linked. Yes, right. Okay, then. Well, you are on the right track here with your input. Now, I don't want to make things too easy for you. And this is why the data protection regulation distinguishes between two basic types of personal data. Personal data, and only using the abbreviation PD, personal data, following the GDPR, this is a point that you need to keep in mind. If you are the one who gathers or processes personal data in a company, or if you're dealing with employee data, this is something that you need to keep in mind. So there is the normal personal data. So there's no specific term for it. Normal personal data includes the address, telephone number, date of birth, email address. And then there is a special category of data. I'm going to touch on that point later. I'm going to talk about why there is racial and ethnic background. So normal data is the basic data set. This is something that you are allowed to process on the basis of the relevant laws. You need to take care of that data, but this is uncritical data to start with. But then there is a special category of personal data which are defined in the data protection regulation. Ethnic migration, ethnic background and racial background. I find it difficult to deal with these terms, but that is the language from the law. So you need these terms so that you can find them again if you search for them in the legal texts. That's exactly what the text of the law says. A special category is the racial and ethnic background, political opinions. Very interesting. Religious and ideological beliefs. It's also another important field. Trade union affiliation, genetic and biometric data. Genetic, that is something that you hardly have to deal with ever. Biometric means pictures and videos. And with pictures, we have to deal with a lot in our online world on an ongoing basis. Health data, data on sex life or sexual orientation. All this is data that belongs to a special category. And following the GDPR, this is data that needs to be specifically protected. That means if you are in charge as a data protection officer or as a processor of data, you need to ponder about how you protect that data, what the legal basis is to gather this data, who else is allowed to access and process this data. So there's a chain of extra measures attached to this category. The law stipulates that this data is so sensitive. If anybody wants to process it, that needs to be, this type of data needs to be protected specifically. Political opinions and religious convictions and beliefs, this is something which doesn't play much of a role in our day-to-day business in most of the cases. The point of biometric data, in other words, photos of a person, if I send a photo to Yara so that she can put it on her flight, this is a type of data that needs to be specifically protected, and hardly anybody of us would be aware of it. It's something that we take for granted. You post these pictures on Instagram and Facebook and put them on a flyer, but those who receive this photo are obliged to take care of that data. So, should I find my photo after 5 years that I sent to Yara after 5 years, it would be worthwhile to ask the question whether this data is still protected. GDPR says that you are not allowed to process data unless you look for a legal basis that allows you to do so. And this particularly applies to data of this special category. Whenever you enter this special category, it might be a dating app, it may be something that is health related, all those tests that were carried out during the COVID pandemic. Whenever you want to gather this type of data, ill or not ill, in these situations, the law stipulates that you need to pay particular attention to this type of data. No matter where you work, whether you are self-employed or an employee, it's important for you to know that you and your data, when we're dealing with this type of data, that this data is particularly protected. So I see two questions. If a physician's office enters your data into Doctolib or similar tools, how should we respond? So if such a question comes up, you have two options. You either can turn to those responsible for data processing, it would be the physician in your case. You can tell them what kind of documents they have. You can first try to get an overview over what really happens to your data. Is this a questionable tool, or does it only look like a questionable, or is it something that is pretty robust? And most of the cases, you don't get far. The shorter way, the more efficient way, indeed, is to turn to the supervising authority, because that's their responsibility. That's why they are there. You can send them an email, give them a call, and ask them what they think about this transaction. And if you have the suspicion that something goes wrong, you can file a complaint with this supervising authority. And they are much more easy to deal with than their reputation suggests. They have the mandate to give advice. They are interested in making sure that processing happens in the proper manner, or to make sure that data processing wouldn't take place where this cannot be guaranteed. These are your options in such a situation, and you have to choose one of both of these tools. I would first turn to the physician's office and ask them what they are doing, and if they can't give you any information or don't want to give you information, then I would turn to the supervising authority. And an intermediate step could be to make use of your right for information. So you can send in a request for information. And there's a question, for how long can I store photos of specific events? Storing of pictures is very difficult as a topic. It warrants its own workshop. We first needed to distinguish what you can see on this picture. Is it a particular historic event? In a theater performance, that's a question whether this is the case or no. Do you see the actors or do you see the audience? So that is something that you need to take a look at. And I'm not going to make any general statement on this case, because no matter what I say, it would be wrong. So what does it mean to pay attention to and take care of this type of data? If you gather biometric data, if you collect photos of your employees, then you need to think about where to store it, who has access to that data, to these pictures, and how can I make sure that only those can access the photos who have the right to do so. How can I make sure that the data doesn't disappear, that they would be backed up in an encrypted manner, and that they are going to get deleted when I don't need them anymore? What this means in the final analysis is that if a data protection violation should take place, an hacking event, a former employee takes the external hard drive home or whatever else might happen, then it's only a question of the penalty imposed by the supervising authority. If it's data that you can also obtain from other sources, it's something that would not experience such a high penalty. But if you got 2,000 photos and you don't know what happens with them, then the supervising authority is going to get pretty annoyed. What's behind of that is that the more sensitive a set of data is, the higher the damage can be with those who are affected by this data breach. And this is a consideration. And this is expressed in the amount of the penalty imposed at the end. What should be more important is the consideration in the run-up. If I'm collecting data as a data controller, it should be my vital interest to keep this data as safe as possible and secure as possible, because I don't want anybody to abuse that data. The idea is that what you don't want to happen to yourself, you shouldn't enact on anybody else. So let's assume I'm an actor, an actress, and there were nice photos from a photo shoot. They land on a weird website where somebody manipulates these photos with Photoshop. This is something that you don't want. Basic obligations. Well, there is an obligation which is not really very popular. I'm talking here about the record of processing activities. Maybe you can just give me a yes or no in the chat to express if you have ever seen or established such a record of processing activities. In Article 30 of the GDPR, it's written that each controller, and where applicable, the controller's representative, shall maintain a record of processing activities under its responsibility. Well, and the chat says no. I've seen that in a contract, but we don't have it well established. There is another yes. Would know about it, says somebody else. So when we talk to clients or discuss things with a new client, we start talking about this record of processing activities. The General Data Privacy Regulation says that a record of processing activities has to be maintained, which needs to include the following data: name, contact data of the person responsible, of the representative of the controller, and if you have a data privacy officer, the data of the data processing officer. The purpose of data processing. And here we're looking at the wording of the legal text. That means that you need to establish what you process data for. What is the purpose? An email address for a newsletter, for example. Then you need to describe the categories of persons of whom you process data. This is employees, customers, applicants for a job, or whatever you might think of, whatever category might be applicable to you. What also needs to be included is a description of the categories of personal data. That's exactly what we have discussed so far. Master data, category employee data, genetic data, health data, and everything that has something to do with biometrics and health is very important when you deal with employees. That also needs to be included into this record of processing activities. You also need to determine who is the recipient of this data. Who receives this data through background activities of software and tools, including third countries, that is, non-European Union countries and international organizations. Idina, I've seen your raised hand. I'm going to turn to you in a moment. So which data transfer into third countries? That needs to be established, and you also need to determine whether these data transfers are secured by guarantees, whether there are any security measures in place, and you also need to determine when this data has to be deleted, time limits. And if possible, you need to describe which measures have been taken to secure this data. Irina, well, I'm wondering, you were talking about a record of processing activities. I, for one, operate my own website. And of course, you have some colleagues mentioned there. But this record that you mentioned, does that refer to my clients who are looking for me and leave a comment, or does that also apply to people who are listed on my website? And where do I have to keep this record? Well, that's a good question. Thank you very much. And Annegret also raised her hand. Fire away. Well, I've got a very similar question. Could you give us an example about these records? We're in a registered association, and is a record something else? But we've got a list of people of whom we process data. Well, answer. This record of processing activities is less complicated than it seems. There is no predefined form for it. Katharina also has a question. Well, we have a record of processing activities since 2018, but we don't have the legal basis expressed in it. So the question is, do we have to refer to the legal basis, that is the text of the data privacy regulation? Is that mandatory to be listed as well? Answer. Now, this record doesn't have any predefined form. There are some guidelines of supervising authorities regarding its possible structures. There are templates issued by various companies or associations who are active in the field of data protection. You can do it in a very complex manner, and there's an excellent software available that helps you to digitally maintain such a record. But basically, it's not more than an Excel spreadsheet. You first have the purpose of processing newsletter, and then you then determine the category of persons of whom you could receive personal data, as there are customers, potential customers, website visitors, participants, everybody who could register for a newsletter. And then in the next column, you have the type of data, email address and family name, Christian name, whatever you gather for this newsletter. And then you've got a column with the indication whether you're dealing with a special category, which is not the case when you just capture the email address. In the next column, you determine who else might receive this email address, to whom it's being transferred. When it's about a newsletter, it's the software that you use to keep the recipient list, Sendingblue, MailChimp, Rapid Mail, whatever you use to send your newsletter. And in the last column, you determine the measures that you have taken in order to secure this processing activity. This could be a contract between you and the software which offers the newsletter tool. So that's basically what it should look like. The legal basis can also be included, but it's not mandatory. And it may even be too complex very often. Fundamentally speaking, we're talking about a documentation kept by you about the data, which determines which data you gather, for which purpose, and by whom. And this newsletter example is quite a fitting one. If I want to send a newsletter, what I need is an email address. If you just consider during the last newsletter registration, the kind of data that you entered, it's your name in 99% of the cases. So you need to consider, do you really need the name of the recipient to be able to send the newsletter? Well, that's the structure behind it. Now, in the ideal case, and here we're reaching a point where things become more difficult, this record of processing activities is meant to reflect all processing activities that take place in your professional environment. If you think about that for a moment, you will notice how complex things are going to become. because a processing activity starts with making the telephone call, it goes over the messenger, an email program, a CRM system, a newsletter, social media, and then I've got the website. I also have got the statistics on the website, and I also use diverse programs and software in my company to process personal data. So it's going to be quite a load of things that you need to cover. Now, there is an exception and an exemption in the data privacy regulation about those cases where you don't have to keep such a record of processing activities. That's something that people love to refer to, and I can only recommend to you to keep in mind that it very often doesn't work. This exemption means obligations do not apply to companies and institutions who have more or less than 250 employees. That sounds to be a good idea, unless the processing activities might pose a risk for the rights and freedoms of the person affected. Well, here we need to take a look. If I got a complete set of data about Yara, about the communication on this workshop, telephone number, email address, her name, the address of her, and this data gets lost on the web because I was just clumsy and my infrastructure got hacked, I believe the right and freedom of Jara has been violated. Yes, sure, it has been violated because she has the right to have her data protected, and she has the freedom to decide who should receive the data and not, and who should not receive it. And if that data is to be found on the web, this freedom would be infringed upon. So that's the first point where things become difficult. And the processing of data doesn't happen on a random basis, particularly when we look into a professional environment. I'm dealing with personal data on an everyday basis. There is no way around it. There may be some exemption or exceptional cases. Let's take an actor, for example, who would be recruited on a regular basis and doesn't do much more than that. We could discuss about his right to refer to this exception. But then still the first point applies nevertheless. And the last limitation is that data would be processed that belongs to the special data category following Article 1. So this exception is out there as a rule, but it is connected with so many limitations that I can only warn against using this exemption to enter into discussion with the supervising authority. This is going to go south. And now we've got the question, what are DSG or the GDPR compliant newsletters that we can use? We're going to talk about that when we talk about software. How are data secured? Do we have to conclude a contract with the service provider, although we believe that the data is secure? That's indeed the fact. If a third-party provider or a data processing company, which means it's a different company to whom you provide data on a regular basis, like newsletter data, you provide that data to a data processing company, you provide them with email addresses that you have gathered over the website, or provider of accounting software like Datev, or a payroll accounting service. Wherever you provide data to, you are engaging with a data processing company, a third-party company. And if you want to put that onto a robust legal basis, then for the time being, the only thing possible is to conclude a contract between the provider and you regarding the data processing. And most of the major platforms provide such declarations or contracts. They can be just concluded by ticking a box online. It shouldn't be much of a problem, I believe. But if you believe something to be safe, and you only believe it to be, then this is not a robust legal basis. This is going to cause problem if push comes to shove. And then we've got another point. The data of Yara, don't we find them on the web? We are part of the data for sure, the email address, the professional email address, for instance. But if I also got a telephone number as a result of my communication and I extend my data set, then I very quickly deal with data that is not easily available on the web. Last question, would that also apply if I only give my address without my name to a newsletter provider? Yes, it still applies, because the problem is that you cannot define upfront which data would be provided together with the email address. An email address, info@ is an anonymous email address and cannot be associated with a person, but somebody could also register with werner.schmidt@Datenschutzhelden, and you already have personal data together with the email address in the form of the name of the person. So my recommendation, my urgent recommendation, and I'm going to get back to that point when we look at appropriate software, is that wherever data would be transferred to other parties on a regular basis, put that on a contractual basis. So this as far as the basic obligations for controllers are concerned. Well then, take a deep breath. After the record of processing activities that you and your company should keep ever since 2018, it would be fine if that were all that there is. Well, it's not the case. There's more to be done. There's a second aspect. These are the so-called technical and organizational measures, TOMs, or TOMs. In the guideline for the record of processing activities, you can read that these measures should also be spelled out, but it's not an obligation, as a matter of fact. That means the technical organizational measures are a list of measures to start with. It's as beautiful as the record of processing activities, in which you document how you want to guarantee the safety of personal data that you process. In concrete terms, this means that you bank on the encryption of data memory media, that you maintain passwords for laptops and smartphones and secure them by means of a backup. But it also means that the door to your office is secured with a key, where not everybody's got the key. So it starts from very simple things like access control, who can access my office, who is not allowed to access, down to more complex topics like which contracts do I conclude with service providers, how do I protect my IT infrastructure. All that needs to be covered in the so-called technical and organizational measures. And you find for this topic also guidelines, recommendations, and good templates online. You just need to take a look at them. Very important for you is to keep in mind, if you are in a situation where you process data on behalf of others on a regular basis, like you do payroll accounting for others, or you work regular for the same customers in their marketing activities, you have access to their website, their social media account and things like, then you have to establish technical and organizational measures and maintain them. For all the others, it is still recommendable, although not absolutely necessary. Now, that causes work. And together with the record of processing activities and the technical and organizational measures, we're talking about this advantage that we talked about at the very beginning. Data protection has a lot to do with paper trails, but it not only causes work, and this is something that we experience very often when we talk to our clients. You first take a look at what the company does in order to guarantee the security and safety of data being processed. And in the course of this process, you stumble over gaps. You always find gaps. Something might have been overlooked, and the cleaner has got 3 reserved keys, or whatever might happen. There are the most weird things going on. Or documents wouldn't be shredded, but just put into the waste paper bin. It's just things that would be overlooked in the course of your business activities. And by means of these technical organizational measures, you very easily find things that are flawed. Well, as I said, Here it's up to you to decide whether you want to establish them or not, but my recommendation is to at least think about these measures with reference to your own activities. Whether you lay them down digitally or in writing is up to you, but think about them at least. Should you deal with data of a special category on a regular basis because you've got employees or similar categories, my recommendation would be that basically understand the terms as a mandatory task. There's a question. Now, if I work for a group and I help them do their payroll accounting over an online data platform, in other words, I've got access to an email account to which people send their invoices, and I enter the invoice data into spreadsheets over the data platform, is that also my obligation then to hold these measures or to maintain these measures, or is it the ordering company who is in charge? And how do you work then as a freelancer? Well, yes, I would be a freelancer. Right then, if you work for them on a regular basis, if there is any kind of regularity in your activities and not a one-off thing, then you are a data processor. That is something that you need to understand very clearly. And where do I have to hold these measures or document them? Is it a spreadsheet that I keep at home? Well, in your case, it would be just the other way around. Now, we need to be careful here. Otherwise, we are going to get lost, also in view of time, but I'd like to sketch it out. There is one entity responsible, the company that you work for, which is looking for external service providers to carry out various activities on behalf of them. That's quite easy when we're talking about craftsmen or cleaners, but it's more problematic if we're dealing with a person who gets hold of a lot of sensitive data in the wake of their activities, just like it happens when it comes to payroll accounting. Now, this company that you work for decides that they want to work with a freelancer, so a self-employed person, and not as an employee. Right? Now, in this moment, you need to have a contractual basis so that the external party is allowed to take a look at the data. And before you start and are allowed to start working for them, the person responsible should turn to you and ask you, Irina, which measures have you taken in order to secure these data? And what does your contract for data processing look like? In other words, the controller, the person responsible, needs to make sure that whoever works for them would create their own safe and secure framework conditions. And that is where the data processing contract kicks in. If you get such a contract, and it's very pleasant for self-employed and freelancers, you are basically, from a legal perspective, you're seen like an employee. It's not so bad if you get hold of data that you basically should not have. Everything would be nicely defined then. Question, and I need to make sure that I've got the firewalls in place in my computer, that I've got the safety systems in place. Right, you are. That's exactly some of those measures. Let me give you a simple example. There's a password on your computer, and it would get into a blocked mode when you leave the computer for 5 minutes. Say somebody rings at the door, somebody comes in, and they can't take a look at your screen. I don't want to make much of a fuss about it. In reality, out there in the real world, when it comes to sole traders and small business, small companies, it's very difficult to keep all those documents in place. And very often you don't have to pile up loads of paper. Now, the problem here is if an incident happens and such an incident has to be reported to the supervising authority, and they kind of come to understand that somebody employs 10 freelancers and never thought about what happened to and what happens to this data, and an incident occurs, then things can go ugly. And there is a certain justification for it, I believe. Well, I don't want to cause panic amongst participants, specifically when we're talking about activities that you can do quite nicely as a freelancer. The work to document everything is limited. You need to take 1 or 2 days time. You need to work your way through templates and guidelines that are available. You probably need to prepare some pots of coffee and write down what your measures are. But it's not a bad thing to be done. It happened various times where startups approached us and said, hey, guys, listen, we need such a contract for data processing for others. We need the technical and organizational measures because we want to become active for larger companies, and they don't allow us to work for them. Unless we've got such a list of terms, we don't want to discuss them with them. We want to tell them from the day one that we're well prepared and it works. For the other party, it means that they can just let them do what they believe needs to be done. They are well prepared. They thought about the safety and security of the data. That makes some work and causes some work. You have to wade your way through them, just like in a tax declaration, but it also brings a couple of more bucks on your bank account in the case of doubt. There's a question in the chat. Can you recommend a website where you find contracts regarding data safety that newsletter providers should conclude? Well, it's rather the other way around. Newsletter providers and data processes like newsletter platforms, they should maintain such a contract because they are the ones to define their own technical and organizational measures. If a newsletter provider does not have such a list of measures, I would rather take a close look at what they are really doing. Second question. If I work for a cultural institution as a freelancer and take care of their media account and have access to their social media account, and I use my own smartphone and laptop, who's in charge of establishing these measures? Well, if you work for them on a regular basis, which is most often the case when it comes to social media, and then if you have the access to the social media and the password and you can access it 24/7, you are a data processor and you need to take care of your own technical organizational measures. And that's a difficult field. The whole social media field is kind of a minefield. And just like take a look at the 50% of marketing activities of our company. If I look at the data, Facebook and social media data of people who want to apply for a job, who sent their complete CV, who got a health problem when we're dealing with a physician's office, then I have to admit that, yes, we've got a lot of data. Only because we take care of the Facebook pages of other parties. So basically, we needed to sit down and get our papers in order. In our activities, we're very often dealing with small companies, with startup companies, and particularly these points, data processing on behalf of others, technical organizational measures, record of processing activities, they cause a whole lot of uncertainty. If you work as a freelancer, these documents very often can be put together or just a couple of pages. Don't feel insecure. Either work your way into the topic, depending on your preferences, and my recommendation at this juncture would be that there are podcasts to listen to when it comes to data protection. If you listen to them in your own time, you can gain a lot of knowledge which goes deeper than we can go on today's workshop, and this will make things clearer. Now, if you're rather a person to require a compacted form of knowledge, I recommend to organize 1 or 2 hours of consulting from a data protection officer. Let them explain the basic topics and take the time to set up everything that is needed. Do not reach a point where you think, oh my God, I don't care. What about all this fuss? I better leave it. Now that's a bad decision indeed. The smaller the business, the easier it is to set up the basic documents. It sounds a little bit tragic, but it very often isn't as comprehensive and sweeping as it sounds at first glance. Now, that leads us to another point, the flip side of the coin. Which rights do we have as individuals, the data of whom is processed? What are our rights? And the most important right is the right to transparent information. The data privacy regulation says that data subjects have the right to be informed transparently about the processing of their data in an easy-to-understand language. If you remember the last checkboxes that you ticked in an app and you tried to read the data privacy rules, you will probably believe that it was not very understandable. So there's claim and real world experiences, but it's important for you to know that you have this right. If you turn to your insurance broker, or if you want to have financing, or you want to buy a car, you can also ask your counterpart, hey, tell me, please, who gets my data? What happens with the data? Tell me more about it. So we have a right to be informed about that. We have the right to information and right of access. That means that after this workshop, I can send an email to Yara and tell her, well, Yara, tell me, which data have you stored that refers to me? And what do you do with my personal data? This can be important at the point in time where you have the suspicion that something goes wrong with your data. It would be given to somebody where you don't want your data to end up with. That very often happens whenever employees are dismissed, when they want to get back to their company and retaliate, because this right to information is sweeping and goes into detail. And of course, you can put some obstacles in the wheels of companies that are not well structured. What's important for all of us is to know that no matter who holds data of us, we may ask them which data they keep, what kind of data they have, and who they transferred it to. And you can try it out with your mobile phone provider in order to understand what kind of data they have, what they have access to. We have the right to erasure. That means you are not happy with the service provider anymore. And if that's the case, you can send them a message to the extent that you ask them to delete the data that they hold on you. I leased a car a couple of years ago from a car dealer, and the leasing contract expired. I returned the car, and still I receive advertising via mail. I don't like that. So I can turn to this car dealer and tell them, listen, I want you to erase my data. Of course, this company is allowed to keep some data, tax-relevant data, billing data, and things alike. But everything that goes beyond that has to be deleted, has to be erased in full. And we have the right to object. That means we can say at any time, hey, listen, I don't want you to continue processing my data. That only works with regard to the future, of course, not retrospectively. But these are not all rights that emanate from the data privacy regulation, but the most important ones for both parties, for us as individuals whose data is being processed by somebody, but also rights for us as business people, because we know that these are the rights of customers, of employees of ours, which they can claim. Marco asks, how do you have to verify erasure of data? Fact of the matter is that there is no specific definition for how data has to be erased. One could say it is something that is based on the principle of good faith. Should it be the case that you invoke your right to have your data erased, and you ask a company to erase your data, and you have the suspicion that they didn't do that, or not fully, you, of course, could then turn to the supervising authority. They then can go much, much deeper in their scrutiny than we are allowed to do as data subjects. Now, the exciting question here is, and I'm going to shorten the documentation a little bit, do you know about these rights? Do you know that you have these rights and you can use them at any point in time? And it leads us to the next question, which is even more exciting. In your company, in your professional activities, are there processes which lay down precisely what happens if a data subject invokes these rights? Say, if a customer or a client who I worked for 10 years ago and he writes me a mail to the extent that I want all that data of mine to be deleted, is there a process in place that tells you what to do, or are you lost? And then there's a question which I'm also interested in. Have you ever used this right to information yourself? And put it in the chat, please. It's a very exciting point indeed. And it's also recommended whenever you turn to a credit investigation company, the Schufa, for instance, the German Schufa. If you want to know which data the Schufa, the credit investigation company in Germany, has about you, you can turn to them. You have to pay a certain fee, but they are obliged to give you an excerpt of your data, about all the data they have. You need to search for it on their website. You find it in the lower part, kind of hidden. You enter your own data and you get a letter sent to you, and you see which kind of credit cards you applied for, which requests had been submitted to Schufa by banks or other parties. It may be quite informative for you. Let's change tax into the world of marketing and take a look at the whole topic of consent. Why is that? Everything that has something to do with consent happens in the field of marketing. And this consent is a difficult thing to get your head around if you want to be compliant with the data privacy regulation. Now, there's a short question. What happens if somebody leaves the company? Do you have to automatically delete all data that you don't need anymore? Yes, you have to. The data privacy regulation provides the call for minimization of data. Keep as little data as ever possible. That's necessary. If you keep a database with photos of employees and an employee leaves the company, you need to make sure that this photo is being deleted. When it comes to photography, I believe that is the topic which ends up in front of courts most often, because an employee says, for instance, I left the company half a year ago, but still see my photo on their website. I told them twice and I fed up with it. I turned to the court. And normally this company will have to pay damages. And there's another limitation in the chat. Certain data for employees have to be stored. Nevertheless, yes, that gets us back to what I said earlier. Data subjects have the right that their data be deleted with certain exceptions. There are colliding legal interests like tax, insurance aspects and things like, where a company has to store certain data for a certain period of time on a mandatory and legal basis. Payrolls, insurance documents and things alike. So there are certain statutory limits, but once such a statutory limit has expired, we would get back to the point of data erasure. So after a limit has expired, this data needs to be deleted. An image film. Can I use it where various persons are to be seen? Well, that's another point that you can engage in a nice debate in. There is a consensus around that when we're dealing with productions, it might be a lavish brochure, an image film, a promotional film, or whatever this production is like, that these productions can be continued to be used when the input needed to redo such an image film is in conflict with the interest of a person who has left the company and still to be seen in this image film. Now, these topics very often end up in front of courts, and the final result is, I believe, very much up to the mood of the judge on this very day. But we're going to touch on the whole topic of film, photos and videos and what to do in this field. Normally, this is generally accepted, it very often happens that we want to make an image film, we need your photo, we prepared a sheet of paper, and you can give your consent that allows us to take photos of you. And that's exactly what I was talking about. If I don't have any other legal basis, then we can process personal data on the basis of having a consent of the data subject. Newsletters and things like. This is where you use a consent. You obtain the consent of the data subject so that you can process a certain set of data for a certain purpose, and only for this purpose. Such a consent, according to the GDPR, needs to fulfill a defined condition. If you gather an email address for a newsletter, you are not allowed to use that email address for any other purpose than the newsletter. That already tells you that things are getting a little bit more complicated. And now things become even more complicated, particularly when we talk about films, videos, and photos. Consents can be withdrawn with a view to the future by data subjects at any point in time. We know that from newsletters, we register for a newsletter and we can unregister. And once I've unregistered, I don't receive any new newsletter anymore. And that's exactly the problem. I'm saying, yes, you can take a photo of me or a video of me. A video is being shot, the film is being produced, and 2 months on, the employee leaves the company and they would say, hang on, I don't want to be seen in this video anymore. So with a view to the future, the employee, the former employee, withdraws their consent. And that means, basically, that the image film cannot be continued to be used. Now, the problem here is that you can either start talking to the employee and negotiate it, or you negotiate it in front of court. But you don't want to get into the situation in the first place. And this is why our recommendation is, when it comes to these things, to not work with a consent, but with a model contract. That means if you plan a certain project, a production, you not only have an employment contract, but you also conclude a contract where you recruit the employee as a model. Of course, there are tax aspects to be discussed with a tax consultant and legal aspects to be discussed with lawyers. That's not our realm. We only focus on data protection. We don't have any other expertise in other legal fields. That has to be said very clearly. And for the participation in this image video, the employee gets a kind of reimbursement. Some chocolate, bottle of wine, some extra euros or whatever. And on that basis, the employee assigns the right to use the pictures to me. So if you invest that money into advertising campaigns, a lavish brochure, a promotional film, a video, image video, or a podcast where you don't want to delete them in 2 years' time, if you do that, just dig deeper when it comes to model contracts, because they are much more conducive than consent. Consent is always nice when we're dealing with data that doesn't hurt me if this data is gone, newsletters and things like. But when it comes to photos, it's probably not the right means to be used. It's widely being used, but it causes problems later on. Where you can still use it is the typical, if you hold a presentation, you organize a workshop, or you organize and offer dog training, a yoga course, and you want to take photos to put on Facebook, then you can think about consent, because it wouldn't cause much problems if somebody says, please delete my photo here. Now we've got a whole set of questions coming in. Can we conclude by a work contract that material can be used after the termination? Well, you need to turn to a labor lawyer, a lawyer expert in labor law. I can only answer on the basis of my gut's feeling. I would say a labor contract is a labor contract, which doesn't have anything to do with marketing, photos, and things alike. I believe, that's my gut's feeling, that these things are mutually exclusive. And I haven't seen such a labor contract. And if that happens, I would always do that on the basis of a second contract and not within the form of a labor contract, because that is something that is going to cause problems for sure later on. And I've got a documentation of a stage production, film photos, if you want to use them. should we use then a model contract in addition to an actor's contract? Well, an actor's contract is another problematic point. I'm not an expert in labor law, but when it's about an actor, I would believe that they understand that they provide their job as an actor. And if the contract says we are going to record your activities, that's more understandable as compared to normal and other labor contracts. Usage rights in the framework of a fee, assignment of rights through a fee contract. Well, I'm not a lawyer, again, I have to say that. Now, there is freedom of contracts in Germany. I can negotiate anything in a contract, whatever I want, unless it collides with other interests laid down by law. But I don't cherish it very much. It's still a guts feeling thing again. I do not believe that that's a good idea to cover too many diverse aspects in only one contract. If everything fits and is dovetailed, it's nice, but it probably makes more sense if you define the various areas separately from each other and you lay them down, negotiate them then in separation. Particularly when you're doing a recording on video, we're talking about the right to your own picture, usage rights, limitation of usage rights in space and time. You should be very much alert. What I can promise is, I believe, is that the more transparent you are in dealing with the people you're recruiting, the easier it gets to find a solution. Susanna says, when it comes to performing part, it's part of the work. That's exactly why I'm saying when it comes to actors, it's an aspect that is part of their daily work. But this not explicitly applies to actors, but the whole topic of photos of employees is a very important aspect for any kind of company because they want to present themselves to the outside world. And then Caroline has raised her hand. Well, I don't know whether this goes too far, my question, but what I wondered is if I put together an Instagram story for marketing purposes of a premiere and I take a shot of the audience, a lot of people sitting there just to show, oh, there are so many people that turned out to attend this premiere. Are there rules or laws which stipulate from which size of a group on you are allowed to depict a group without having their consent? Well, let me repeat it. Data privacy is my field, and then there are other legal parts and fields where we can only reflect our guts feeling, and we're not allowed to give advice and to consult. What you mentioned goes into the direction of the right to your own image, photos of an individual person and things alike. Now, the documentation of events is the header under which all that happens. That means you document what is important to the world. And what is important to the world is something that you can define on an individual basis. If it's only about two people, it's probably difficult to make that claim. But when it's about state production, there are reasons to invoke this aspect. Now, the criterion is whether you focus on a particular person, that's the situation, that you cover an artistic performance, or you put together an image film for your company, or you take a shot of the whole audience, like you described in your question, where you focus on individual persons, but not specifically so. So this is what you can bank your arguments on. You can document what happens in the world. That's important. And then if you do that, you're pretty safe. Not 100%, because when it's about photos and videos, there's nothing that is 100% safe. That has to be said very clearly. But things should normally go smoothly. Things get more bumpy. And my advice is, before you publish something, take a look at it again. If you think, oh, they are so cute, like they are smooching here in the cinema hall, I'd like to stay on them for 5 seconds, and they're already in the focus for a certain period of time. You need to be aware of that. And Anja has a question. If my image film is being shared, and it ends up on a site of a political party, say, because it has been shared by somebody. Am I, as a company, responsible for that? Do I have to get that image film back from that political party and their website? Answer, well, we need to start at the beginning. Let's just assume that we're dealing with a YouTube video and you made sure that the legal basis is okay for whatever is being seen in this video. You have the right to use for an unlimited period of time on all platforms without any regional limitation. If that is the case, not much can happen to you because it has been made available to a broad audience. You can also not control who shares a video that has been posted on Facebook. But it becomes more problematic if those who are to be seen on this video were not aware of it. So if everything is right and you got the legal rights firmly anchored, nothing can happen. But it becomes problematic if somebody uses this video to act in a malicious manner. If that happens, we're dealing with two areas. Predominantly, it's either pornography and everything associated with it, or right-wing activities, misogynistic or misanthropic activities. Then you could be claimed as responsible to have paid attention to your data. So you need to take a close look at what happens to your data. But then again, we're also talking about the internet, and you cannot control everything. In America, in the United States, there have been major court trials because a video that has been captured privately by an ex-boyfriend has been posted on a porno platform or things alike. So a lot of weird circumstances have to coincide here. But my recommendation would be not to act too swiftly. Check before you publish whether you've got the legal basis firmly anchored, whether you informed everybody who is to be seen on this video, and then you can post it. So there is a residual risk which is going to remain, just like when you drive a car. There might be a speed trap, and if you were 5 kilometers per hour too fast, well, things happen. But the rest of the year, you won't run into that speed trap. What can I do if my photos are to be found on a website? That's a question posted by Evelyn. That's a classic case. If we just take a look at the rights again, you have the right to have your data deleted. You can make it. You can make use of it. If somebody has put your presentation online, it can be very bad for that person. If you don't want to be seen, switch off the camera, switch off your microphone if you don't want to be heard, and if you want to ask a question, nevertheless, you can enter this question over the chat. If you don't want to get filmed, and it still happens, and if that ends up on the web, that can indeed cause problem, and you as the data subject can invoke your rights. And if the organizer rejects your claim, you can turn to the supervising authorities. That's their essential task. In other areas, you would resort to a lawyer and draw the counterparty to court. There is nothing more unpleasant rather than to be filmed. There's nothing to do with data privacy. I just don't want it. I just reject that. That's it. That's the basis for it. Oh, well, we've got a lot of things to cover. It's great. Wide field. So we have already covered a whole lot of topics around the consent in our discussion. Let's take a fresh look at it. This consent. If you want to bank your activities on a consent, then you need to be able to show and prove that you have this consent. Let's take the newsletter example. If you have a reasonable and good newsletter software to which people can register, then the newsletter software sends an email to you where you have to confirm your registration. It's a double opt-in procedure. You have to confirm twice that you want to register. And when you click on that link, yes, I want to register for that newsletter, a timestamp would be put into the software when you gave your consent. So if somebody then maintains that they never gave their consent, you can show that this consent has been given. If it's about practical consent in your daily life that can be laid down in writing, where you say, yes, I want to take a photo of you, whether you should do that, it's a different topic, but you decided to use such a consent, keep that piece of paper as long as you need and use this photo in order to be able to show that this consent has been given to you. Consent for photos shouldn't be included in a labor contract because this consent needs to be given in an accessible and easy to understand manner. That means whatever you give your consent to with this declaration, it needs to be explained to me in such a manner that I am able to understand it, so that I understand what happens to the things that I gave my consent to. That's a mandatory requirement, and we can say that the ideal world not always coincides with the real world. If you just think of consent declarations with Microsoft or Apple or any other player or a dating app, how easy and understandable all that is, I don't believe that it's always understandable. And this consent needs to be distinguishable from other areas where you can hear my office dog being very active. I apologize for it. So that's why everything that has something to do with a consent, I wouldn't put it into a labor contract. So the consent itself is one matter that you either accept or you do not accept it. And there's a last counter-argument against anchoring it in a labor contract. The consent needs to be voluntary. It must not be tied to any condition. So you've got your labor contract and you also have to sign that we are allowed to take photos of it. This probably would make the labor contract invalid and the consent as well. There was the keyword of a tie-in ban. It was covered by the media 2 years ago. Do you want to get our great PDF, How to Cope with Life Better? Just register for our newsletter and everything else, and you will get this PDF file. This never works properly with a consent because consent needs to be given voluntarily. Silke raised her hand. Fire away. Can't hear you. Now it works. Right. I've got a question. In our PR department, we use photos that were shot on events where we haven't given the mandate to take photos. There are various organizers, co-organizers. In such a situation, then, should we document the contract and the consent that allows us to take these photos and post them on Facebook, or are we anyhow moving in an undefined area, a gray area? Well, things are pretty gray here, and my only recommendation that I can give you is to document as much as possible, secure as much as possible, particularly when it comes to events. You might have seen that. People tend to make use of banners which say, photos are taken here on this event. Or what I've also seen, and I like that very much, if a photographer takes photos on an event where various people take part in, they get a sticker or some other sign that tells the photographer that these people who wear this tag or whatever it is don't want to have their photo being taken. That brings across that message very clear. And in all other areas, you need to define the legal basis, unless you're dealing with covering events of the world. Yara. Well, I think I saw an overlap between a labor contract and fee contract. And there are also work contracts where usage rights are being anchored in this contract. That's being done widely And I believe it's also right. So let's assume that I've given you the mandate to hold this workshop. We concluded a work contract which lays down that we are allowed to provide this video and post it to a larger audience. Can you then in hindsight say I revoke my consent? Because the consent can be revoked at any point in time. But if something like that is being anchored in a fee contract, I'm not talking about a staff photo or employee photo. I'm talking about the production that I have ordered to be done. Right, that's why my statement earlier on was very important. We can only cover the whole small aspect of data privacy, data protection, which only refers to consent. All the rest is not our field of expertise, but be it as it may, when we talk about data privacy, all these topics boil up and come up. Depending on the structure of your own contract, your work contract, and we can glean it from the chat, there are fee contracts, work contracts. There are various types of contracts, and these types of contracts give you leeway to decide what you anchor in your contract. If we have a case like this, I hold a workshop once and I assign my usage right. I do not give the consent. Then you've got the usage rights, which has nothing to do with the consent given. And this usage right can be limited by myself. I can tell you, you can only post it on YouTube. I don't want to see my workshop on Pornhub. Or you can say, you've got the unlimited right to use my workshop. So you have various options available to you. But when it comes to a labor contract here, we've got the conditions of a consent. I would not make a consent part of a labor contract. And if I have got a labor contract, if you still use these and need these photos, you can make use of a model contract where you assign usage rights. Or you can either also alternatively work with a consent, which is being done very often because those responsible believe that this is a simple way to secure yourself, but it's not. So, and from here on, things become even more complex. Social media events and things alike have to be regulated in detail. You need to take a careful look at what your best option would be. And my recommendation would be to, in case of doubt, turn to a lawyer from the respective field of law. It's not our field of expertise because there are so many different legal fields that are involved. I wouldn't like to just put together a reader on the basis of some short Google research. I wouldn't do that. Newsletter registration needs to always contain double opt-in. Yes. GDPR compliant newsletter tools is something that we're going to cover when we talk about tools in general. Last point regarding GDPR, incidents. If, I hope it never happens, but it still happens at times. So should a data protection incident happen, simple example, you notice that you've been having a Trojan on your laptop. You do not know what kind of data left your laptop, but you know that you operate a payroll software on your laptop. It was open and you used it during that period of time. You prepared invoices and edited photos for other clients on your laptop. Now, in such a situation, what is most important is that it would be most unwise not to do anything. The simple reason is you do not know what kind of data left your laptop and what is going to happen with this data from here on. I try to talk slowly because it's also important. You first need to understand that shit happens. Something happened, something went south. Things can happen. Stay cool. And in the next step, try to find out what really happened in detail. Well, it may well be that you have to resort to external know-how in the form of an IT expert, in the form of an IT security technician somebody from this realm who's got more knowledge, who can find out what kind of Trojan you were dealing with, what kind of data can be retrieved by this Trojan, whatever the case may be. Once you've done that, and that needed to happen very fast, don't wait, act swiftly. So once you've verified what happened, turn to the supervisory authority if data was stolen. They will never be enthusiastic, they never are, but the supervising authority, and the internet, you very often get the recommendation, stay away from the supervising authority, they only want to be a pain in your neck. No, they are a good ally very often when it comes to these incidents. They've got a lot of expert knowledge, a lot of recommendations and tips to give to you, and they are in the position to be able to help you along. So my request is, if you've got the suspicion that something went wrong, take these 3 steps that I listed here and take the necessary conclusions. If you deal with personal data on a regular basis with IT and software, then you may want to take a look at a cybersecurity insurance, or whatever the name is that insurance providers give to it. They are reasonable in terms of costs, and very often, and that's important when it comes to these types of insurance, they got a clause very often which says that special know-how is being provided in the case of an incident. So you can have that covered also in your insurance. You have to decide it yourself. But what is important is, should you have the suspicion that something happened, that there is an incident, take a careful look. Check whether data was stolen. In some cases, it's simple. We had a panic call by a customer who said, by a client of ours who said, you know what, my company smartphone, I lost it. Smartphone contained patient data, employee data. I can't find it anymore. And if something like that happens, we're also getting nervous. There we start to sweat indeed, because we're starting to think of all the things that need to be done. So we think of the classic recommendations to document what kind of data was stored on the smartphone. Can it be located? Has it been switched on? Was it switched off? And then we had, after 6 hours, another call by the client who said, well, you know what? I found my smartphone in my fridge. Everybody happy, nothing has happened, nothing bad has happened. Fine, things can end this way. But, and here comes my recommendation, if you've got some time at your hand, try to go through such scenarios of a possible incident and try to determine what could happen. Could you get hacked? Could you be hacked? Could you lose your laptop? Could somebody enter your office at home and this unauthorized person sees documents or something on your screen that they are not allowed to see? What can you do? What can you do to prevent something like this from happening? And I think I saw a raised hand. Yeah, you talked about insurances. Only recently, when I concluded the private liability insurance I saw, it was very affordable, that you can get insured as a private person. Is that also possible? Well, whether it really makes sense for private individuals may be up to you. If you lose your smartphone or if online banking is being hacked, you probably have other problems rather than dealing with your insurance. But for companies, it may be meaningful and reasonable, because the second step, when you use and need external know-how, it can be very expensive. IT specialists are prohibitively expensive. If you have to book them for 10 hours and they uninstall your infrastructure, it may set you back thousands of euros, and the cybersecurity insurance may come in as a big help here. There is another question regarding emails and contact forms. For reasons of time, I would put it on the back burner and get back to it later on, because there are so many questions. We're lagging behind in time by far, but we have managed well through the whole topic of general data privacy regulation, and we're approaching the topic of security. things will be more relaxed and better structured, easier to understand from now on. Cybersecurity has been mentioned on this flyer of ours. Cyber is a term that I find difficult to deal with. Cyber is being used very often. Russia threatens to wage a cyber war. There's cyberspace and things alike. So cyber is everywhere. It's not bad, but I prefer to call things the way they are, the way you intend to use them. Cyber is a nice thing, but what we're dealing with across the next couple of slides is internet safety. What can I do to protect my devices? And online internet activities can be subsumed under cyber, but cyber encompasses such a wide field of topics that I find it very difficult to use this term. I believe, and I hope, and I keep my fingers crossed, that this is something that everybody takes for granted. Each device needs to have the software firewall. That is an application which makes sure that not everybody can enter your device and that your devices would be secured by antivirus software. Why is that so important? More than 114 million malware were developed in 2019. Android is one of the least secure operating systems. Things became a little bit better ever since 2019, but only a bit. And 90% of them are Trojans. And in most of the cases, it will be with you just like it is with us. We have our email software running on the workstation, but we also access our email over our smartphone. We use messenger programs. We can access our accounting software, contact management systems and things. You don't want to have Trojans on neither your computer nor your smartphone. And this rumor that all Apple users are not affected by security problems is something which is not right. In 2018, 90,000 new malware programs were developed only for Mac operating system devices. It was slightly less in 2019, but still 60,000. 60% of these programs are Trojans that want to retrieve data. 30% of malware is viruses. They want to destroy something. 10% are scripts. Scripts allow you to do quite a whole range of tasks. You can take over computers. And 4 or 5% are backdoors. These are backdoors into operating systems by means of which you can do a lot of data manipulation. And that shows you where this development is heading towards. 70% Trojans, 60% Trojans. This is about data theft. That might be customer data. Microsoft had a case where more than 60,000 data sets of company customers ended up on the web. That happens all the time, and you don't want that to happen to you. What you also very often are not aware of is that 70% of German companies were the target of internet attacks in 2021. Now, you believe they would target BMW and Continental and large companies like that. It's not the case. They also cover and attack small companies, small and medium-sized companies. So it's a very realistic threat from the web, from the cyberspace, as it were, against which you can protect yourselves with an antivirus software and a firewall. Most providers offer software that can be run on Mac, Windows, iPhones, Android devices in parallel to each other, so that you don't need to have a different software for each device that you use. You can use the same provider across all your devices. That makes it easier to administer. And this is just 40, 50, 60 euros every year, depending on the provider you use. And that is money to be invested, that needs to be invested. And you should also cover your smartphone with this protection software, firewalls and things like, because you have so much malware running on smartphones. And there's another point that many people are not aware of, and that's the topic of encryption of emails. We have become accustomed to believe that emails are a good channel of communication. We send an email to an email server somewhere in between. This server does something to our email and sends it on to the recipient of our email. It's a so-called transport encryption in such a case. That just means, in basic terms, for the stretch from me to the server and from the server to the recipient, the message is encrypted and halfway secure. But particularly in this middle server, there are points that can be attacked because your email has to be processed, and there is no end-to-end encryption in this email. Now, there are remedies, excellent remedies to be used here. PGP is the expert term to be used in this context. PGP encryption has been around since 1998, but it hasn't not really asserted itself and become popular. PGP is a combination of digitally signed files and a public and a private key. You've got a public key and a private key to be used. I don't want to go further into detail of this technology, and the big difference here is that if you use these two keys, public and private, you can make sure that the mail would be encrypted, gets encrypted on your side and can be decrypted only by the recipient. And this is something that needs to be applied to all emails that have something to do with personnel and employee data, that has something to do with photos, and that should be a standard for all these applications. That allows you to make your communication more secure. And ever since we had the wide coverage in the media talking about WhatsApp not really being encrypted, we have been discussing whether messengers programs really have end-to-end encryption or not. That we have the same problem with emails is something that has escaped our attention, as it seems. My recommendation in this context is to take a close look at PGP, turn to your IT expert, or do your own research on Google. And most of the popular email programs support PGP. Outlook Thunderbird can do that without any problem. And PGP doesn't mean that you're cut off communication. You can select whether or not you want to send an email in an encrypted or a non-encrypted manner. That's a great way to secure your email communication. My warm recommendation to you is to make use of PGP. Now we've got two other questions regarding emails. Contact form, okay, we're going to postpone it. And signatures in emails with a data privacy declaration. What does usage of Wi-Fi on the road mean? Well, these are cool questions, but I'd like to postpone them to a later point in time because it takes some time to answer them, and we'll see whether we have that time. Is that also applicable for all mails, is the question? Yes. PGP. If you get through this process of encryption, you will receive a public key that you can provide to all recipients of your email, and your private key that only you own. The other side has to do the same. You've got an encryption mechanism that allows you, you've got an email program to send this encrypted email with, and your counterpart can open and decrypt the email that you sent. And if the counterpart doesn't have this key, nothing bad can happen. All that happens is the recipient can't open the email. Something else was not much of a topic before the COVID pandemic, but it has become more important ever since. VPN, virtual private network. That just means that I've got a structure in place where I've got a company network within your company headquarters, and you've got a situation that you are on the road or at home and you want to work in this intercompany network. To assure and to secure this data transport, you can establish a VPN, which just means that your laptop digs a tunnel into your company and uses these company infrastructure through this tunnel that attaches and adds an extra layer of security to your communication infrastructure. If you work in your office at home on a regular basis and you use company infrastructure then on a regular basis, that is something that needed to be considered urgently unless you use it already. It is something I believe that all larger companies have already established, and they are much aware of it, of the need of a VPN. Other than that, VPNs are popular to watch YouTube and videos in other countries. That's also nice as an application, but has nothing to do with our field of application here. And there's another point that not many people are aware of. What everybody knows is that in your smartphone, on your laptop, on your computer, you've got a hard disk, some kind of storage media on which to store data. And if you forget your laptop in the subway and I can get hold of it, I can open it, extract the hard disk and read all that data, unless you encrypted your hard disk. That works on laptops, Windows computers, Apple computers. It also works in smartphones. That means that your operating system gets encrypted by means of a PIN, a password, a code, a fingerprint, or whatever it is that decodes it. So all the data on your hard disk is encrypted. If I uninstall this hard disk, I've got your hard disk, but I can't enter your data because it's locked, encrypted. So that's a very superficial explanation of how it works, but I think it explains it quite well. That needs to be standard for everything that you do in a business context to store data. There's no way around it because all operating systems offer it out of the box. There were some times where you had to buy additional software and do things alike, but BitLocker is the name in Microsoft. Vault is the name of Mac OS. It doesn't have any name in mobile operating system. You just need to check that it's running, and that needs to be done. Let's put it in more concrete terms. Marco said, yes, there are also Linux users. But if you use Linux, they know their way around. I don't need to explain that. But of course, yes, you will also have the opportunity in Linux to encrypt hard disk encryption and to activate hard disk encryption in Linux. But I don't know the name of it. To put it in more concrete terms, if an unencrypted, non-secured laptop or smartphone gets lost, you forget it somewhere. And as employee's got a bad day, headache, and forgets, or it's being stolen from your car, which happens very often. Such an incident needs to be registered and reported to the supervising authority, and you can rest assured that the authority is going to become pretty annoyed because they don't understand how it can happen that somebody operates a professional device without encryption. But if the final device has been encrypted, you still need to document such an incident internally. Laptop gets lost, got lost, but everything has been encrypted. But then, if it has been encrypted, you don't have to report it anymore. That's a huge difference. It can make a huge difference in terms of reputational damage and penalties to be paid. And there's no difference whether you work as a freelancer or as a company. There's no way around it. And for all major company structures with more workplaces, it's anyhow an obligation to encrypt everything. And then there was the topic of cloud storage that came up. I understand it because it's a great tool. Now, there are a couple of things that need to be kept in mind in this context. Cloud storage providers are data processors, almost always. Because if you store data there on a regular basis, you also store personal data there on a regular basis. Let's take a simple example. I want the photos of my staff to become accessible for various employees so they can edit it. I store it in the cloud so that people can access this data. The most providers of cloud storage offer that, and they also provide the required contracts. Most of providers in the European Union, that has to be said, and we need to keep that in mind. The safest version, if you want to make use of cloud storage, is to encrypt your data that you want to store locally on your laptop, and this encrypted data is then stored in a cloud storage. Now that's a lot of fuss. You need to download it and decrypt it. For others to use it, you can't interact. It's a nice version, but it's not really conducive. A good alternative for that are self-hosted solutions. That means you order somebody to put together a server or a hosting package, and you install the software on the server, you install it, administer it. The hosting provider doesn't have access to your data, and if so, only in a very limited manner, because you build up your own infrastructure. You know what happens in this storage. You can define your own security because you have selected your own software that you want to run. The software, like Nextcloud, is something which is really cool with a lot of features. You can share links, you can do collaboration, you can read documents online, edit them, but there's a catch in it because this software has to be administered by somebody. And if you're not a Linux user like Marco, it may well be the case that it's not so easy to be done because you don't have that necessary expert knowledge to do that. So the consideration then is whether you should not rather turn to a provider who provides these services for you. And that's okay if you just keep in mind a couple of aspects. In the first step, you need to take a look at the third-party provider who you turn to. You need to take a look at your service provider and take a look at what kind of third-party providers they use. So you've got a provider from Germany, it looks good, and in the data privacy declaration you find a passage which says that this provider transfers data to 600 companies in China, in US, in Russia. Now, that makes this provider ineligible. In the ideal case, you also find out which software infrastructure this cloud provider uses themselves. Do they only use open source software like Nextcloud? Then things are fine. Open source means freely available software on the web, and they offer this. They just administer for you and update it. Or alternatively, they might have developed their own software that is associated with the problem that you cannot really understand what the software contains. There is not much public information about this software then, proprietary software on the web. But the provider should residing in the European Union so that the provider is subject to the data privacy regulation. In the ideal case, they would reside in Germany or Austria. Then you don't have a language barrier. Particularly when it comes to the general data privacy regulation, there's a lot of expert terminology in it. We've got one client currently who has been trying, I don't know for how long, who has been trying to get a good contract by a British company, and they cannot agree on the terms to be used, the vocabulary to be used. It sounds ridiculous, but that can be really a lot of fuss. US providers, and these are the ones that you find immediately when you Google them, they are the ones who, in terms of costs, are interesting and attractive. Now, these US providers should not be used for the time being, according to my point of view. We don't have a proper legal basis for transferring data to the United States. That's a problem. This can be disputed in some areas for Google Analytics for websites because the data set itself is very limited. When it comes to a cloud storage where you store a lot of different type of data, here it becomes more problematic. It may well be the case, though, that OneDrive and Google Drive is something that you cannot avoid. If that is the case, the controller, the person responsible, needs to consider what kind of technical and organizational measures and other security mechanisms can be established in order to justify the usage of OneCloud or Google Drive. My recommendation is to take a look at and search for EU providers. Take a look at their data privacy declaration, because there are also black sheep out there. Check what they do, and this is what you do then in order to select your own provider. If you don't want to host your own server, which very often cannot be done by small companies. So take a look at the cloud storage provider, because you store a lot of different data there, and everything should be watertight in such a cloud storage. Magdalena has the following question. Can we recommend somebody to administer Nextcloud? Well, not really. Metzner are doing a good job, and we keep our data there, and they administer our data. There are other providers out there also. You need to take a look at what you really need. It depends on how much storage you need, what your budget is. So you need to do your own research. Last aspect regarding security, and then we're going to have a short break. Far too late, I admit. Passwords. 2021, the top 10 passwords were 1, 2, 3, 4, 5, 6. Password 1, 2, 3, 4, 5. Hello. 1, 2, 3, 4, 5, 6, 7, 8, 9. Words, Schatz, Baston, Berlin. No. That's definitely a no-go. If you think you have such a password, after this workshop, go home and change all the passwords you have. There is no discussion around that. You need to do that. It's totally clear that passwords should be complex, should be complicated. And of course, as a result of that, it's difficult to remember them. UGHZ and all the rest of it are difficult to remember, but there are cool tools just for a little money. Password managers, NPass, 1Password, and things like. There are a lot of providers of antivirus software who also include a password manager in their security solutions, which you can use across various devices and sync them. You have the same set of passwords on your laptop, on your desktop computer, on your smartphone, and the password manager itself can be secured with a fingerprint or a very strong password, a long complex password, or your facial recognition. And that means you've got all the other passwords ready at any time. You can use passwords that are as complex as can be. And this is what I recommend to you to use. And this is something where it doesn't matter whether you are employed or self-employed. In 2022, we all have the problem that we need passwords for online banking, Facebook accounts, and any other things, no matter whether we use them in our professional or private life. And solid passwords are the strongest pillar in your security structure. You will have seen that the Facebook account of a friend has been hacked into, and things happen then, data being manipulated. And when that happens, the reason are weak passwords in most of the cases. At this juncture, people tend to say that passwords need to be changed on a regular basis. Now, this approach is changing. There are those who say that as a result of the ongoing changes, passwords are getting weaker over time. I, for one, believe if the password is strong and complex with a lot of special characters and things like, you can use it for a year or two. And then you need to also determine how sensitive the data is that you protect. My online banking password is one that I change on a regular basis, but the same doesn't happen with my Facebook account. And what is even more important than changing your password on a regular basis is how safe your password, how secure your password is in the very first place as a result of its complexity. So get hold of a password manager. Make sure that your passwords are complex enough. There's a question in the chat. Can I trust the password manager? I believe you can do so if you select the right password manager. These are not for free solutions. They would set you back €1 or €2 per month, or you pay €30 once and that's it then, which is what I prefer. The password for the password manager should be a complex one, a longer one. And this is used to encrypt this password data. And this password data is encrypted, which nobody can access. Now, recommendations, well, it's just a matter of taste. We use NPass, 1Password, and there are various other providers out there that you can use. So if you really want to study this field, you can make use of tests and test reports which lay down the pros and cons. Very often it's a question of budgets or features that you need. One criterion for us is that we need a lot of different entries. A password manager for just 10 entries doesn't help me much. There's another question that came in. Would you recommend a cybersecurity for a freelancer and a sole trader? And if so, which one? Recommendation? Yes. Wherever you use data and process it on a regular basis, you should have such a cyber insurance. So this is not only personal data, but particularly in those cases where you deal with photos, as it is the case with everybody who works in the creative industry, social media, and you always have to deal with photos and images. In such a case, I would recommend to conclude a cyber insurance. My recommendation is to turn to an independent insurance broker. It's difficult to turn to a particular insurance company because their representatives can only sell the products of their insurance. In some cases, you also have to pay the insurance broker a consulting fee for their consulting activities, and they then choose an insurance which fits best to your needs. So that is my recommendation. Which insurance company you should turn to is something I cannot answer because it very largely depends on what you really need in your particular individual situation. Software, that's our next topic. We already touched on it, but I'd first like to give an overview. If you're looking for software, and in the chat we had the topic newsletter coming up, newsletter platform, but what has been said about that can be transferred to all other software providers. Which are the important criteria? It's the seat of the company. Is it Germany, European Union, or a third country that is outside of Europe? What you also have to pay attention to are group structures that are pretty complicated. WebEx would be an example. WebEx is one of those video conference tools. And if you look at their website, it looks like a German platform. Everything is in German language. Everything has been explained in German. But when you look behind the curtain, you see that WebEx, what's behind it is Cisco, a US provider. You've got a group structure where the mother company is located and resides in the United States. But that means in legal terms that American law applies. That means you've got a problem with your basic foundation. This can be remedied if there is no way around it. But if you want to take a simple approach, look for a provider from your own region. Zoom, everything applies here as well. It looks very German, but it's a US provider. And then next up, you take a look at the contractual basis. Is there a contract for data processing, a data processing agreement, a standard contractual clause, or is there no clause, no contract at all, which also happens. And if that is the case, stay away. And the third point is something that has come up also. Once you've done the first two steps, you take a look at the third-party providers that the provider uses. Does your provider pass on your data to many other companies or just to a handful of providers? And the last point, does the provider consider data privacy? Is there a dedicated area on data privacy? Do they offer an FAQ? What's your first impression? And this is very telling indeed. I brought along an example. There is a German mobile phone provider who very much cherish data privacy and sustainability. And if you look at their website, you will see the normal content manager. And before you give your consent, you will not be tracked. And once you've given your consent, there is one tracker following you. Just a counterexample for that. If you access build.de, you will be followed by two trackers before having given any consent. And once you've given your consent, the data captured during surfing is being passed on to more than 150 third-party tracker tools. So this is how you can determine very quickly which provider is to be given preference, although these two industries cannot be compared to each other, but it's an excellent example. Now, let's take a look at the topic of websites and cookies. We've talked about newsletters, and 2022, most of the people who follow a self-employed activity, who have a self-employed business or already have a company, websites play a very important role. And I'm going to stay pretty superficial here when it comes to websites, because website itself is very technical. And very quickly, if we wanted to go deeper, I have to say we don't have the necessary knowledge to understand all details. The publisher of a website, that is you are responsible for everything that happens on your website. This responsibility cannot be dedicated to any agency or web designer or to the hoster, the hosting company. You are the operator, the owner of the website, and therefore you are responsible and accountable. Particularly these days, there is a wave of written warnings sent by lawyers for Google Fonts. Google Fonts is something that allows you to present fonts on your website, very nice, beautiful websites for fonts, for instance, and these fonts are being loaded through Google websites. And some law firms started to send written warnings. The first thing that happens is such a warning letter being sent to the owner, and a penalty is being imposed of 150 to 200 euros. And the first question would always be, why did the advertising agency not take care of it? It was not their job, or maybe they have put together the website at a time where this law has not yet applied. So very important for you to keep in mind is that you are responsible. And if something goes wrong, you cannot delegate responsibility to others unless when you order the website to be designed for you, you have already agreed with the provider that they also take care of the whole topic of data privacy. That's the only exception. And this basically touches on the core problem. You either need deep technological know-how if you want to understand what happens on your website, or a counterpart who has this topic or who has that knowledge, which is not the standard anymore, unfortunately, because many websites are being put together through model and template systems, and those designing it don't necessarily understand what happens in the background and still sell the designed website to their clients. This has nothing to do with the visual quality of a website, not at all, but very often, and we have seen that in our own daily experience, very often we see that those who designed the website didn't know what they put together there. They only looked at the visual appearance, but that doesn't help you because you are responsible. You need a counterpart who can explain to you technically what happens on your website, which data is being stored, whether you gather statistics, which servers process your contact forms and other data requests. Check carefully who you tie yourself to. And if you want to test a programmer, a coder, or a website designer, there's some terms that you can annoy them with. It's the consent manager, or the data processing agreement, server logs, or SSL encryption. Katja, you've got a question? Right. I've got the question, what does it look like with international websites? I work in an international team, and which law applies? Do I have to pay attention that the German and European law, that is GDPR, is being complied with? Well, there are two principles that can be applied here. First is the question where the seat of the company is. Is it Germany or abroad? In this case, it's the Netherlands, in my case. Okay, so initially, then Dutch law applies. That's the first point. And the second question, which audience does the website address? If you offer services for German users, then the German requirements, legal requirements, have to be applied. And this is how you have to check your activities. The more international a website is, the more complicated it gets. And there is one phenomenon to be observed, and particularly in providers like WebEx and Zoom, in their websites, you don't find an imprint. German law stipulates that each website needs to have an imprint. Now, this is not the case under US law, and that's why they are saying, you know what? Our company is a US-based one, and we know we don't need an imprint, and we have more customers and clients in the United States than in Germany, and therefore we don't have to follow German law. So particularly in larger company legal departments and marketing departments try to find the respective loopholes in the laws of the jurisdictions they are active in. The more international a website gets, the more complex it gets as well. So fundamentally speaking, we can say that the General Data Privacy Regulation imposes the most stricted data privacy law worldwide. California, though, has issued an amendment of their data privacy law. In Switzerland, they are working on a restructuring of their data privacy law. But the European Union's GDPR is the sharpest sword. And when you comply with the GDPR, you're well positioned in other countries as well. What happens on such a website? Let's take a closer look at it, because it's very often being underestimated, and the website is your face to the world, and everybody who is unhappy with you, it would be the easiest lever to use against you if they want to annoy you. And therefore, I looked at the website of the Association for Performing Arts, the Media Library, and when you access this website, you will see the consent manager where you can give your consent or not, and if you don't consent the presentation of YouTube, what happens in the background is what you see here on this slide. That's just normal for a website. You see some fonts being loaded, some scripts that are important for various features. Files are being loaded, which makes sure that the website appears the way it's meant to appear. That's totally unspectacular, totally normal. But if I activate YouTube up front and I say YouTube can also be loaded, the following happens. I still have got my little block on top coming from the performing arts, and everything else, this longer list on the left-hand side, is being loaded through YouTube. I don't want to go into detail here, but what you see here are processes and structures, particularly in websites, that you need to have explained to you if you are the responsible person for websites, or you need to have the necessary know-how to understand it in order to consider the next steps to take. And this is why, when it comes to websites, check carefully who you collaborate with. Antje. Yes, I understand that we are in charge and responsible, and often they're not. There are fixed-term contracts, and my company, my association, cannot put me into a position to hold this information because I'm the operator mentioned in the imprint. What can an association do to be on the safe side in the case something goes wrong? If I take myself as an example, I cannot train people in such a depth that we cover all the necessary technical details. So that's why I'm explicitly asking that question. So if I understand you correctly, you are an employee of the company. Right, I am. Now that means there's a management, board of directors, or whatever you have in your company. And they are the ones who are responsible. Right, they are, but it's not realistic. When you take a look at the necessary expertise in place, let's be frank, even board members don't have the opportunity to really work their way into all the details, technical details of website design. Right, that's correct. And here I have to repeat the recommendation of before. If you have a counterpart that you work with, this counterpart should really be experts in their field. If you commission an agency to do the website for you, they also should know what needs to be done in terms of data privacy. They should be able to give you advice what can be put into reality, what is easy to be implemented, and what is more complex to be done. And if you operate a complex website, you need to resort to a data privacy officer who needs to have the necessary know-how. I don't know what the reason is, particularly when it comes to data privacy, although it is a very relevant topic for each individual participant here. We see that our data is being processed wherever we look, by YouTube, Facebook, and a whole lot of other agencies. You always try to get along with little know-how. Everybody understands that they have to send their car to a garage for a technical inspection. They don't have to do it themselves. It would be a bad idea, everybody knows that, to stand in court alone without a representation by a lawyer. But when I'm dealing with this complex process, and websites very often are very complex, I need that representation. I need that particular expertise. I need to have that technical knowledge about what happens. I need to have, secondly, the data privacy knowledge so that you know what to comply with. And in the ideal case, you also need to be able to understand what the goals of the company is and are. And you can't offer all that if you just by chance are mentioned as the operator of a website in the imprint. Well, you either can qualify your staff who is responsible, and this means that you have to second them away for 6 months for further training, or you have to find a different solution. Now, for websites, data privacy explanation and imprint need to be two different links that are separated from each other. You always needed to use this SSL encryption. Although it has been around as a technical standard for ages, not everybody applies that. And the difference can be seen if you open a website and you can enter HTTP : / and the page is being loaded. That means that all the communication transaction happens in an unencrypted manner. If you only access and can access a website only over HTTPS, that means that everything is secure. Contact forms, this is a question that came up. Only retrieve those data and request those data that is really necessary. If you want to have a request regarding a product or a service that you offer, then I don't care about the date of birth of the customer who is making this request. Online shops are very sweeping with regard to the data that they require. Stay away from this approach. It's going to go wrong. And if you see somebody who does it, give them a recommendation that this is not a good idea. When you have additional tools on your website, statistics, analysis, whatever, third-party providers that are popular, like videos, as we have seen in the page of the Performing Arts Association Darstellende Künste, or in real estate brokers, there are plugins that they use in real estate advertisings. Always put a consent manager first, because you always deal with services. And if you want to put job advertisings onto your website, turn to somebody who knows his way around data protection and data privacy. At the very point when you can apply for a job, you have to assume that you get a lot of data. There are various legal clauses and provisions that have to be adhered to and complied with. It's only about publication. If I publish the job advertising, just by publishing the job advertising, I could run into trouble. I know what you mean. The point is the following. Whenever you publish and post a job advertising on a website, and you always can get into contact over the website, you encourage the applicant to send his CV, his photo, whatever you require. And at that point in time, then, you are subject to various requirements regarding application data. This data has to be deleted after a certain point in time. And there's a question by Katharina. Of course, you advertise, but they don't send their data over the website. Yeah, they don't. But they send their documents over a contact address that you offer over the website. So if I only add an email address, the same applies? Right, yes. Because when it comes to advertised job documents, the data processing looks different as compared to other data. And that is something that you need to inform yourself about. You are obliged to render that information, the data privacy information regarding job application documents. That cannot be just processed by some generators. You need to think about it carefully before. Cookie guidelines and the data protection statement, do they have to be on two different sites or pages? Not necessarily so, but that would be my recommendation. Or they could be linked to each other. So with the data privacy statement, you then have the opportunity, together with the statement, to also let people take a look at their cookies. And what has been established in the meantime is something that is very charming, I believe. You either have the opportunity on the website to open an icon and to adjust your cookie settings and change them, or you alternatively have a link that you can click on, which opens a window like the one shown on the right-hand side, so that the cookie settings can be clearly defined. This is good for website operators, because some people think, well, just take my statistical data, you're quite a nice guy or a nice operator. This is quite useful. When you decide at the very beginning, when you enter a website, that you don't want to have any cookies, and then you stumble over videos that you would like to see and you'd like to readjust your settings. So that's quite versatile. You not always need a contact form. Is it enough when I lay down in my data privacy statement what happens with the data? That's right. What about mails? Mails also have to be deleted on a regular basis. When it comes to mails, you need to pay attention to those mails that have to be stored. Everything has something to do with orders or with job applications. There are certain time limitations and time periods that have to be adhered to. If you operate a website yourself, and if you stumble over Content Manager and cookies, what you see on the left-hand side here is neither a reasonably good Content Manager, nor does it live up to the requirements regarding the obligation to provide information. You don't find anything there. And it's not enough to say cookies yes or no. It needed to look like shown on the right-hand side. You need some basic information that your attention is being drawn to as a visitor to a website, and then you can select those cookies that are necessary for the website. That's the essential selection. Do you want to? Do you agree to accept all cookies? So that's what it should look like. So that's a recommendation. It happens very often that website operators believe that what's shown on the left-hand side, which has been put together by an agency, would be sufficient. It's not. For a pretty long period of time, it hasn't been enough. Now, Evelyn sends a question. If I post on Telepolis a job advertising and just have a link to my homepage, well, to cut a long story short, as soon as there are job advertisements on your own website or job advertisings of your own company are being posted on other companies' websites or platforms, I would recommend to have the data privacy statement passage being amended. The danger that somebody gets annoyed by missing information, it's not worth it, because if you amend your data privacy statement, you then live up to your information obligation. There's a question by Katja. The problem here is Google is based in the United States. At the first sticking point in the form, I would assume that personal data is being retrieved. So that's the second sticking point. I'd stay away from this. I promised in the very beginning that we're going to take a look at tools, apps, and software that is widely being used, what their problem is, and whether there are possible alternatives to them. WhatsApp is extremely popular. Everybody knows WhatsApp. The problem here is we're dealing here with a US provider. WhatsApp Business is being strongly marketed and advertised by WhatsApp. And, well, dear entrepreneurs, don't you want to use WhatsApp for your own business, is what they are saying. I warn against it. It's a problem that it's a US provider, and WhatsApp syncs all your telephone book data, your contact data. And WhatsApp has been maintaining for a long period of time that they offer end-to-end encryption, but there are various safety and security experts who put a lot of question marks behind this, and they believe that there are various backdoors that do away with this encryption. Ultimately, for the private area, it's something that is up to you to decide for yourself, but for professional usages, I wouldn't recommend it. Signal might be an alternative, which has the same features as a very good, clear end-to-end encryption. It's an open source software. Everybody can take a look at the source code if you want to do it. Now, you're probably have to re-educate your counterparts, the people who you talk with, to use Signal instead of WhatsApp. In visual terms, there are not much differences between Signal and WhatsApp. Threema is also an alternative. Now, if you are at the point in time where you are starting up your company just right now, it's just nice then if you then funnel your customers and clients to a data privacy alternative. Signal takes days at times before a message reaches its destinations, is what Susanne said. Well, I can't confirm that. When WhatsApp was offline, Signal continued being operational and functional. The next problematic application is Office 365, which is very popular in enterprises. If you want to work properly, you can use it. But if you want to do that, it requires a lot of input in terms of documentation if you want to do it yourself. And the other problem is it's a US provider. The kind of data being passed on to third parties in the background without you knowing about it is not clear. You're integrated into OneDrive, and if you don't have anything else to do, you can take a look at the data privacy statement of Microsoft. It's a bunch of links and various passages put wildly together that drive you crazy. Well, alternatives for that could be OpenOffice, which is an Office software which can run on any operating system. Only Office has the nice additional effect that you can also use it collaboratively over the cloud. Or the version that we used was to just use an old MS Office version 2019, which is a local installation. It also works, and the question is for how long it's going to be supported in the future. Marco also writes in the chat, it's a version which I forgot. LibreOffice is also an alternative. And then there's another topic that we have already talked about, the usual subjects, OneDrive, Google Drive. The problems about that are widely known. You as provider, nobody knows what happens in the background. It's not transparent. And the alternative could be Nextcloud that we have already talked about. Now, I don't know whether you know it. Trello is a tool which is very popular, which offers the collaborative alignment of processes and things alike. It's very nice, nicely done. Easy to use, and I totally understand why people love this app. Now, the problem is very simple. As always, it's a provider in the United States. They've got a large US group standing behind them, and a lot of data privacy statement information is available only in English language. As alternatives could be Senkit or Factro, two providers from Germany, which are not as affordable as Trello. They have the same features and they comply with data privacy regulations. Well, the topic of newsletters, something that I also wanted to talk about, as I promised. Alternatives to MailChimp. Well, MailChimp are very affordable. They also offer cool software. It can't be criticized. Now, the problem again is that we're dealing with a US provider. And the question is whether you really want to send thousands of email addresses and newsletter information to a provider where you don't have a sound legal basis to deal with. Alternatives are Sendinblue or Rapid Mail and other Germany-based or EU-based providers with similar features, with partially less good features, though, that has to be said very frankly. At times they have very complex billing models and pricing models. You have to take a look at them carefully and decide then for yourself which of these providers fulfills your requirements. Google Analytics. If you operate a website, you probably have come across it. It's the analysis tool for websites. And I don't need to repeat the problems as we're dealing with a US supplier. And particularly with Google, the probability that your data from your website would be put together with a lot of other data held by Google already, this probability is very high. And Matomo is an alternative. You can host it yourself. And a cool provider from Germany is eTracker. eTracker offer free of charge solutions for small companies. They provide excellent statistics without the need to use cookies. Now, WebEx, Zoom, Teams, these are also US providers. Now, if you look for alternatives, it's more difficult to find them as compared to other tools. Alternatives that are out there, Jitsi, for instance, and Big Blue Button, they're not so simple and easy to administer, and they have less of these many comfortable functions and convenient features like the big players, but they are more affordable. Jitsi offers you to use your own server for just a couple of euros per month, and they are compliant with the GDPR. If you work in the field of social media, you also probably have come across Hootsuite, which makes it easier to administer your social media accounts. We talked about it briefly before, particularly when it comes to social media. If things go wrong, you all of a sudden are dealing with a lot of data that you have to process. We work for a veterinary clinic. We also deal with health data, not only of the animals, but also of their owners. And you need to be very careful then when you're dealing with health data. And I think things are difficult here in this field when it comes to alternatives. The only thing that we found as a viable alternative is Agora Pulse, which is pretty expensive. So you see there are alternatives which very often put you a couple of bucks more back than the big providers. Now, when you come at the point where you need software, go through the criteria that we talked about in the very beginning. If you don't find anything any provider based in Germany or EU, only then start to look for providers from outside of the EU and take a critical look at them. Don't look at the penny. At times it's worthwhile to invest a couple of more euros, but that gives you the opportunity to write on your website that you give top priority to data privacy. Well, here we are. That's it then. We're over. It's amazing, awesome that you stayed put until now. And even now, I see comments coming in over the chat and exchange of tips and tricks. That happened not very often, that an online workshop went that smoothly for such a long time. And I hope that I answered a lot of questions, that not too many question marks stayed, and I hope that I was able to bring across that data privacy, data protection is a cool thing, and that cybersecurity is a topic that you can get your head around. It just requires to sit down, think about the infrastructure that you have to secure. And very often hear that, what you or somebody has written in the chat, most end the workshop with the statement, oh, there's a lot of homework that we now have to do. Well, I'm sorry. Can't save you that. It just means that you want to learn something. Thank you.